Ok, fantástico. Muy bien. Hello, welcome, ladies and gentlemen, to this distinguished gathering to reflect the minds, the weather religion converses with introspections, and also serves as our compass in the intellectuality voyage. It is profound the honor to have in the our means and a scholar the caliber of the Mr. Dieter Grimm on the intellectual stage. Today is struck daily into a topic and that lies in the core in the human coexistence, the defense on fundamental rights on the constitutional perspective. I wish to express that deepest gratitude to the Mr. Grimm for the generous enjoying for the vital discussion. His extensive experience and vast knowledge in the constitutional matter and fundamental rights will illuminate our dialogue and broaden that range of our understanding. It is a privilege to have his insightful perspective in this forum. Throughout our conversation, we will explore the issues surrounding the safeguarding of this inalienable rights and examine their relevance in contemporary society. We aspire to build a better world through dialogue and reflection, and you, Mr. Grimm, guidance, we will assuredly rise new heights in our understanding. So, without further ado, allow me to commence the witty conversation. In the tireless work to safeguard the fundamental rights, the question arises regarding who stands as the interpreters and guardian as this sacred endeavor. In this grandiose scenario, un wavering titan emerged to fulfill these noble missions. And the mission political power endure within this master siege, please a moment, with is the states and civil society, bearing the radiant torch as justice, fundamental rights, those indisputable pillar as civilization, find their sanctuary within the framework as the states, but also in the Commonwealth world as civil society, whose roles assumes essential dimensions in the defense and propagation in these invaluable prerogatives. However, what occurs in political power in its blindness and recklessness veers away from democratic principles and evolves into a ruthless dictatorship. This is a civil or military nature, which knows no bounds in the subjugation as fundamental rights. In these somber times, civil society is compelled to confront a political power that has solidified its dominance, and in these darkest moments, hesitates not to resort to the force of arms to curtail fundamental rights. The macabre scene painfully reminds an deep vulnerability of civil society in its titanic struggle for justice and human rights. The lives of David facing the Goliath is tyranny. This confrontation, the often wakes in the treacherous sense, is ethics and justice, poses profound philosophical question. From a philosophical perspective, it leads to question the balance between the dominion, state, and individual freedom, between the authority as political power on the moral principles that govern our societies. Political philosophy and expounded by thinkers like Hobbes. Locke and Rousseau have deliberated on the legitimacy as state's power and the limits imposed on authority justice, ideal in extending through how the eras of philosophy becomes the guiding light for civil society in the defense of fundamental rights, reminding us that justice is not a luxury but an inherent right as every human soul. On the other hand, sociology comes in play, revealing how social dynamics and the organization of civil society are decisive in the struggle. Social movements, living examples, its eclectic will become the vanguard as the defense as fundamental rights. Sociology reminds us that civil society is not a mere spectator, but an activity player in the promotions as just society and the resistance to violations as fundamental rights. It is violence between the justice and the tyranny. The back is found not only the courts, but also in the arena as philosophy and sociology in a conflict that transcends mere politics to delve into as morality and ethics. The challenge like antitanic duel between duty and pressure reminds that the protection as fundamental rights is a sacred mission that involves unconscious being who yearn for justice and freedom. In this crossroads, this role as judicial courts becomes crucial, although their performance largely depends on the political context that surrounds them. In the dictatorship, members is the judiciary and renten. Their independence is limited and their ability to defend fundamental rights is constrained by the shadow as they years. Judges are forced to make the momentary decisions as their lives hang by a tree. They are compelled to choose between submitting to the oppressive power to preserve their life, livelihoods, on venturing into exile and banishing the beyond justice. Is this scenario judicial institution pillar as justice do not always remains an emblem in the environment where democracy and respect for fundamental rights are expectations. In this country, moral philosophy embodied by thinker like Kant, challenging us to the question the distance between the theory and practice in detection as fundamental rights. How can we ensure that the silent words as the Constitution become tangible realities in the lives of citizens? Here ethics calls us to action to bridge the gap between duty actions and between premises and materializations. The question, okay, fantastico. In a scenario where participatory democracy and exercise fundamental rights are under threat, political sociology invites us to develop into complex labyrinths and influence in the power. Here, the fundamental who determines the embodiments of rights in reality. Lobbying growth and economic interest can particular will and gender the realization of fundamental rights, the civil society in this context emerge as the guardians constitutional guarantees by define itself merge in the actor compete to shape political society. Question. Okay, one moment, please. Okay, fantastic. Quiero hacer una pregunta en torno a la cuestión. With the intricate interplay between political power, civil society, and the judiciary in the safeguarding fundamental rights, how can it strike a balance that ensures the actualization of constitutional premises and the preservation of justice in the face of ever involving changes and shifting political context? Thank you, Mr. Grimm. The other, nuevamente la cuestión. The interplay between political power, civil society, and the judiciary in safeguarding fundamental rights, how can it strike a balance that ensure the actualization a constitutional premises and the preservation of justice in the face ever involving challenges and shifting political context?
First, let me say that the acoustics are very bad, so I have difficulties to understand you. And if I do not really meet the question that you pose, please let me know. But it's really it's not a good acoustics on this way from Argentina to here. Now, what I can say, of course, is that fundamental rights are quite old. I mean, they originated as law, not as philosophy, but as law in the United States of America in the late 18th century, and then Europe followed in France with the French Declaration of 1789. Germany came a little bit later, but the first constitutions in Germany date from the early 19th century, and they all contain fundamental rights. But I must say that during the whole 19th century and also during the first half of the 20th century, even at that time, fundamental rights were not very relevant in legal terms. Yeah. And the explanation, of course, is that during the whole 19th century, only in the United States there existed constitutional adjudication, that's to say implementation, enforcement of fundamental rights by courts. This did not exist in Europe. So there were bills of rights, catalogs of fundamental rights, but no enforcement mechanism. So that practically they didn't play a big role. This changed in Germany after World War II, with the constitution that we still have now, constitution that was drafted and adopted in 1949. And this constitution had not only a Bill of Rights, it was nothing new, that had always been the case, but it contained a constitutional court. And only with the existence of the constitutional court did fundamental rights become legally relevant. That's to say, people could rely on their fundamental rights against government intrusions. The same happened in Italy after World War II, and then gradually in the second half of the 20th century, most countries in Europe, but also a lot of countries in other parts of the world, adopted constitutional adjudication or judicial review, however you would like to call it. Spain and Portugal followed after their revolutions of the 1975 years. Then many socialist, former socialist countries followed after 1989. So now we can say that having judicial review is the normal thing in Europe. Very few countries that have a constitution and have a Bill of Rights do not have a constitutional court. Among them, the Scandinavian countries that have been countries with devotion to freedom, and also the Netherlands, but I think all the rest have judicial review. So I think one has to say that only in Germany, at least, only through the jurisprudence of the constitutional courts have fundamental rights become bites, so to say. They are relevant, and the government is obliged to keep its activities within the realm of fundamental rights. It's amazing to see to what extent fundamental rights extended their scope and attracted new dimensions. The original meaning of fundamental rights, and this is still the one that is the only one in the United States of America, is that they are defensive rights, negative rights. You can defend yourself if the government, legislature, or administration, or executive, whoever, intrudes into your rights. You can defend yourself and bring a claim to a constitutional court. But this is no longer the only dimension of fundamental rights. They have greatly developed. So what we can see in Germany is, first of all, that the negative aspect, that's to say, the force that fundamental rights give the individual to defend himself or herself, has been greatly enhanced, and mainly by the principle of proportionality. I'm not sure to what extent it has been adopted in Latin America, but one can say that the principle of proportionality is perhaps the most important export article of Germany in constitutional law. Almost always it's adopted, with the exception of the United States, where it is still more or less rejected. And the principle of fundamental rights limits the range. To say, with the principle of fundamental rights, the government is more restricted than if you don't have the principle of proportionality. This is one thing. But then there came a totally new dimension of fundamental rights, namely a positive dimension of fundamental rights. The government may be obliged to act in order to protect fundamental rights if they are menaced by third parties, by private persons. So this is a new dimension, also not yet recognized and adopted in the United States of America, but in Europe all over. And Latin America, you know better than I how it is in your country. But this positive dimension is an important development, an important enlargement of the range of fundamental rights, because originally they worked only in the vertical dimension, that's to say against the state. Now they work also in the horizontal dimension, insofar as the state is obliged to legislate to protect fundamental rights of one person if they are menaced by another private person. Fundamental rights play a role in private law relationships. not only in public law relationships. And this is the most recent development. I can go in further detail if you like later on in our conversation. The most recent innovation is that the range of fundamental rights is also extended into the future to future generations. This is a consequence of the climate change problems that we face. And so the Constitutional Court, relying on fundamental rights, obliged the government already now to take sufficient measures in order to control climate change, so that not further generations will suffer from tremendous limitations of fundamental rights when the problem of climate change becomes even more virulent than right now. This is the first attempt to give you some idea of rights development in Germany. I can go into more detail if you like.
Thank you very much, dear friend. On the other end, as this is the direction, this transcendental importance is philosophical liberalism change, acting is the fundamental architect as both Anglo-Saxon and the Latin American political constitution. In this analysis, we find ourselves complex to navigate this space-time labyrinth in which liberalism on British soil. We speak as a context saturated with led by Oliver Cromwell, and a parallel challenge to the absolutist monarchy is the dynasty. During this epoch, the influence scholasticism intervened with John Locke during his formative years at Christ Church University at Cambridge. This historical and intellectual journey offers us the opportunity to scrutinize in depth what necessitates a semantic metamorphosis and a reconfiguration as the philosophical pillars as liberalism. These very pillars gave rise to liberal constitutional rights, which find with number variation in Germany, the United States, Argentina, and Latin American nations. As the states, is imperative to consider the fierce rivalry that unfolds in the epistemological and ontological realms between free will and the determined influence as human will, whether driven by internal or external causes, including cultural, economic, and other factors interwoven in the fabric as our existence. Such a confrontation not only pertains to politicals, but delves into the depths of ethics and moral philosophy. Thus, the question that arises is, how far can we be complicity in operations before resistance becomes a moral imperative? Inspired by thinkers in the caliber as Thomas Hobbes, John Locke, Saint Rousseau, we are in a century-old debate concerning the legitimacy of state's power in the limits imposed on its authority. Justice is ideal that traverses philosophical eras, extends as the become guiding civil society in its crusade for fundamental rights, reminding us that justice is not a luxury but an inherent rights every human should. Furthermore, sociology enters the stage, unraveling the complex social dynamics and the organization of civil society and determinants in this titanic struggle. Social movements, tangible manifestation is electric will emerge a herald defense fundamental rights. Sociology refreshes our memory by emphasizing that civil society is not a mere spectator but a protagonist in the promotions is just society and resistance against violence is fundamental right. In the balance is justice and tyranny. The conflict unfolds not only in the courts but also on the broader stage. Is philosophy and sociology, a confrontation that transcends mere politics to delve into the depths and ethics. In summary, this challenge poses fundamental question about the realization of fundamental rights and the struggle for justice in a world where theory and practice and the reality. A complex and interwoven dance, philosophy and sociology, an indispensable guide reminds us that this struggle demands ethical response and a challenge to the very structure of society. Finally, we find ourselves immersed in the final epic emerged from clashes between the constitutional court and the judiciary. In this duel, the vortex can sway toward political power, and behind is insatiable economic interest. In conclusion, this protection, a fundamental right from a constitutional perspective, demands a delicate balance between political power, civil society, and the judicial system in their endeavor to materialize the solemn constitutional premise. These challenges, like titans on the stage as justice, underscores the urgency is preserving a strong and vigilant democracy to safeguard the fundamental rights of citizens and dispel the shadows that obscure the horizon is justice. How do you perceive the historical and philosophical underpinning as liberalism in shaping political constitution and the ongoing challenges in achieving justice and safeguarding fundamental rights in our complex and interconnected world? How do you perceive the historical and philosophical underpinnings as liberalism shaping political constitutions and the ongoing challenges achieving justice and safeguarding fundamental rights is our complex and interconnected
I think it is important to understand fundamental rights not only as shaping the relationship between the individual and the government. This is the liberal side of fundamental rights, but it is important to understanding fundamental rights also as shaping and influencing the social relations among individuals. So it's not only a state direction of fundamental rights, but the principles behind fundamental rights and the values behind fundamental rights must also live within society. Now, it's interesting to see that most of the European states had been liberal states for a very long time without being democracies. In the United States, where constitutionalism in the modern form emerged, it came together with democracy. In Europe, for a very long time, there was only one pillar of constitutionalism, that was, so to say, the liberal pillar, but the democratic pillar did not exist. And this had consequences, of course. So I think that fundamental rights are not of a high value for people if people don't have the material means to make use of their freedom. So freedom of property, for instance, is not of value for those who don't have property. And there are a number of other freedoms that can only be used if you are in a position where you have the material means to use them. So what we would say today is that fundamental rights also include the necessary means in order to make use of these rights. I think this is important, an important broadening of the scope of fundamental rights. Of course, you are aware that fundamental rights are not only liberal rights, not only liberties, they are also social and economic rights. And as far as I can see, Latin American constitutions make use of that. The Brazilian constitution, that is the one that I know quite well as the jurisprudence of the Suprema Tribunal in Brasilia. Brasilia makes extensive use of social and economic rights. The German constitution does not contain social and economic rights, but it has an equivalent for it. And the equivalent is that rights also guarantee the means that are necessary in order to make use of a liberty. Otherwise, rights are only something for the wealthy people and are less so for those who are in a less good situation. On the other hand, we have to admit that fundamental rights on the one hand and democracy on the other hand are not always in harmony. Fundamental rights limit the range of democratic decisions, and so they are not completely in harmony. On the other hand, democracy can be a threat because majority decisions are not always in line with fundamental rights. So I would say it's very important to see there is a tension between them. I wouldn't say a contradiction, but there is a tension between them. And one has to make sure that this tension is not solved in favor of one side only, but that a good accommodation, a good balance between the demands of democracy and the demands of fundamental rights are reached. And this, again, is a task that is mainly, it's a task for the legislature, of course, but it's mainly a task, again, for the judiciary and especially for a constitutional court or a general Supreme Court with the powers of judicial review.
Okay, thank you very much. Allow me to delve deeper into this matter, which has paramount importance in the global landscape. The discrepancy between the formal and material constitutions do at times overlook is a significant gap in defending fundamental rights. Jurists often mired in sterile rhetoric must understand that semantic modification alone are insufficient to ensure the practical enforcement as the principle erring in institutional theory. When we look beyond institutional frameworks, if we confront an abyss that undermines the effectiveness, efficiency, and real-world viability of fundamental rights, transforming these rights into a tangible reality demands not only exchange in words, but a profound revisions as the processes that underpin them. Juries and legislators key responsibility is bringing to life the ideals enshrined in the formal constitution beyond mere semantic exercise. The operability is institution responsible for safeguarding respect for fundamental rights relies significantly on the moral and intellectuality as those is key positions the appointments as individual committed to justice the defense as fundamental rights is essential for the proper functioning as these institutions. Integrity and ethics in exercising power and indispensable requirements for maintaining legitimacy as these entities. However, has reality shows us that on many occasions, corruption intertwines with authoritarianism within the institution, ability to protect life, dignity, and freedoms. Corrupt acts undermine confidence in the system, allowing impunity and injustice to flourish. The struggle for fundamental rights is restricted by state repression, which often employs secrets to biases as those rising in different as just in this dark scenario, international solidarity emerges as a beacon as hope, not only citizens, but also intellectuals, writers, scientists, and humanists have a responsibility to transcend partisan and ideological interest in the name is humanity and these lives as those suffering violation is their fundamental rights. Their voices can be a valuable resource for raising global awareness about injustice occurring in every planet. This indifference or silence is nationalized in the face as human rights violation, merely an omission but complicity in an injustice. Therefore, the reflections and imperative, the review of legal structure, the fight against corruptions, and the promotion as integrity are fundamental to ensure the materialization of fundamental rights, international solidarity, and the commitment as the global community are essential to exert pressure on authoritarian regimes and protect those in the dark need. In the context, what are your thoughts on the interplay between formal and material constitutions and the roles as international solidarity in safeguarding fundamental rights in the face of corruptions and authoritarianism?
I fully agree with you that it is of extreme importance that fundamental rights don't remain on paper. but that they have to become real. But of course, one has to realize they don't become real out of themselves. The Constitution doesn't enforce itself. Fundamental rights have to be made material by people. They have to be enforced by people. I remember, comes to my mind that I was in your neighbor country in Brazil when the current Brazilian constitution was drafted. And I had many conversations, gave many talks at that time. And there was a tremendous hope in the Brazilian population, especially with young people, that when you write fundamental right into the constitution, then the reality will immediately be conformed to fundamental rights. This is one reason, this optimism that existed at that time in Brazil, that the Brazilian constitution has more fundamental rights than any other constitution I know. They have close to 100 fundamental rights, I think, which is not a good idea, by the way. But of course, they have to be enforced, they have to be put into reality, and there is resistance. There is resistance. There are people who lose when fundamental rights are enforced, and there are people who win when fundamental rights are enforced. So this is not a matter that goes by itself, but they need support, and they need in the population, and they need a willingness of the governments to comply with fundamental rights. This is also a matter of interpretation. Fundamental rights have a purpose, and the purpose shall be fulfilled within a certain segment of social reality. But social reality is in constant change. So you have to develop a theory of interpretation of fundamental rights that keeps fundamental rights up to date with the development. To say, I have to take the situation of the reality where fundamental rights shall take force into account, so that I find an interpretation that best realizes the purpose of fundamental rights. If you have just a positivist way of interpreting fundamental rights, looking to the text and not looking to the reality where they should apply, fundamental rights will not be of much worth. Now, you are totally right to mention our globalized world and to mention the international sphere. What we can observe more and more is that the realization of fundamental rights depends on their international recognition, not only to their recognition within one state. And of course, we have a lot of international rights pacts. We have them on the universal level from the United Nations, where we have them on the regional level, the European Convention of Human Rights, for instance, or the Inter-American Convention of Human Rights. But what we see is that most of these international rights are quite weak compared to fundamental rights within states, if these states really take them serious. And the United Nations Declaration of 1948 has no legal force at all. Yeah, it is not legally binding. The conventions that were later concluded for civil and economic rights and cultural rights, they are legally binding, but only for those states that have adopted them, and not for the rest. The International Criminal Court, for instance, is only able to enforce fundamental rights protection for those countries that have joined that court and not for others. And so I think this is still a very, very weak protection of fundamental rights on the international level, and we have to improve that. But this is not easy. This is not easy because governments that are not very much inclined to respect the freedom of the individuals, you mentioned authoritarian governments, have certainly not much interest in being subjected to international courts who enforce the rights against themselves. Even in Europe, where fundamental rights protection on the European level works quite well, there are authoritarian systems that try to escape and just do not comply with the judgments of the European Court of Human Rights. If I'm correct, I even think there is a tendency that more and more states turn away, well, not so much, but also even in the European Union, turn away from liberal democracy and go into the direction of more authoritarian systems. And in Latin America, this is not unknown to you as well.
Much, dear friends, Dieter Grimm. In this particular dictionary, we emphasize with eloquence the cardinal premise that in the course of the 24th century, it becomes imperative of a citizenship, a civil society, and political class highly to the cultivation culture that exalts human rights with steadfast convictions and maintain that is this human rights education to the ranks is a categorical imperative. It is capable the amount in all strata is education in nation that both progressing the democratic ideal. Furthermore, I fervently believe that literature, poetry, and philosophical tradition must assume a central role in the civic development as contemporary societies, whether in the confines of Europe or the vastness as Latin America, whether within the walls as academic institution or in the broader reaches society. In these modern times, it is undeniable that the number is large as literature and connoisseurs as the humanistic arts has experienced marked declines. In my view, while scientific knowledge weaks is ability to build the intricate democratic challenges and reconfigure and constitutional courts in pursuit is in the general welfare is undeniably invaluable. It is imperative to balance in with other facets as humanistic talk that awaken human civility in the face of the cruel tragedies that unfortunately still afflict the species. Although this is in this juxtable that through histories and literary figures have committed deplorable actions. It is no less true that when literature and poetry occupy a prominent place in the arts as people, the global landscape is a harmful luminosity and steer toward the environment as workplace. We are deeply desire the need to nurture the politics as humanity with their richness as letter and humanistic art does not solely rest on the sublime case for peace, but also on the reinforcement as empathy and intercultural understanding, great philosophy from the Illuminated halls in ancient Greece to Greek chamber is European reflection. Her argue that a profound knowledge of literature and artistic expressions can serve as bridge between different cultures and religions, embracing libertarian works under Laticus provides us with a broader understanding of the condition and the diversity aspects that characterize our planet. This cultural enrichment, equity, and the ability to appreciate and respect difference to foster constructive dialogue and peaceful coexistence and nation in the global arena. Therefore, the study and promotion is literature and the humanistic arts not only serve as beacons and wisdom, but also the foundation has harmony and understanding in an increasingly interconnected global society. For the question, what is your opinion on the importance of human rights education and the promotion of humanistic arts in the contemporary society, Mr. Grimm?
Again, I must say the acoustics are very bad, and I'm not totally sure whether I understood correctly. But what I can say, as far as I understood your question to me, what I can say, of course, is that the law and especially fundamental rights, in order to be effective and in order to become formative, have to be rooted in society. They are not only a matter for legal persons, for judges or for advocates, but they have to be rooted in society so that it becomes too costly, so to say, for politicians to violate fundamental rights. But this is a matter, of course, also, I think, for the education to a very large extent, not only for legal education, but very much for legal education. I understand that you are not in a law department, but in a social science department, if I'm right. What I can see is in Germany and many other European countries that the social sciences are not sufficiently aware of the importance of law. So very often you can find a curriculum of sociology or a political science curriculum in good universities where law plays a very minor role. And what you can see, for instance, in the United States is, I think, even more problematic, because in the United States there is a strong movement to say that the law doesn't really matter. Judges do not decide cases according to the law, they decide it according to other criteria, their personal conceptions of what is just and unjust, or their personal interests, or they try not to get into conflict with politicians. And this is not my experience, and certainly not my desire. The law gains from, the law is made by politicians, but from the very moment on where it is adopted, it gains a relative autonomy from the people who made it. And the application of the norm should not depend on what politicians think it is. So I think this is a very dangerous movement, an intellectual movement, very dangerous to say the law doesn't really matter. These are other forces that matter. A rational choice theory. Everybody maximizes his own power and his own interest. And I think if the law is administered in the right way, it's just the opposite. It is not what is my interest, what is the interest of my class, or what is the interest of my political party, but what is the purpose of the law. And I think that this is important. And when I teach in the United States, I try to say that this so-called realism is not a realism, but it's a distortment of the law. And my recommendation, of course, would be to pay more attention. Of course, we all know that there are abuses of the law. And of course, we know that there are countries where courts do not decide according to the law, but decide according to the desires of the government. That exists, but this is not inherent in democratic judiciary, and is not inherent in constitutionalism, but it's an abuse, and one should call it an abuse and not say this is the reality. The reality can be different. We have sufficient examples. What I say is not an ideal that you cannot reach. It's a possibility that can be practiced and realized. You may know that, I'm sure you know, that I was a judge myself for 12 years in the German Constitutional Court. And these North American realism doesn't correspond with my own experiences. I hope this is sort of an answer to what you had in mind.
Thank you very much, Mr. Frank. Dear Professor, due to time constraints, you must now our conversation to close. Do you have any final word you would like to share?
I didn't understand it, sorry.
Dear Professor and Frank Grimm, due to time constraints, we must now bring our conversation to a close for the time. Mm-hmm. Do you have any final words you would like to share?
Yeah. I mean, since we speak to an Argentinian audience, I would very much like to encourage those people who might hear us or might profit from this conversation that they see that fundamental rights are tremendous value if they are respected. And not everybody realizes what he or she would lose if the fundamental rights were no longer part of the Constitution and of political life. But this is not only said to Argentinians, I said that to my own countrymen as well, of course. Thank you very much for that opportunity.
Yeah. Thank you very much for you, Mr. Frank. See you later. Yeah. Bye-bye.